All right, I'm live on YouTube. I'm live on the gram. Peace to the gods. What's going on? Hope everyone's doing all right. Welcome to the Jonah Bay Show. Goes on every Monday. So what we gonna talk about? We're gonna talk about something y'all was been supposed to have did, but I never told y'all to do it, and y'all didn't do it. You know, one of the first federal rules of procedures I ever told y'all was Rule 17 because I was teaching y'all about authentication and what authentication means. And authentication gets you the original certificate of ownership of the straw man, which is called the birth certificate, official birth certificate, right? So that is also called a counter deed. So then I had y'all look into Rule 17. Then y'all said y'all wanted to sue. So I had to teach y'all about Rule 8. Rule 8. So that they wouldn't do a Rule 12b6 on you, where they say you have made a claim where relief cannot be granted. If you do Rule 8 correctly, they can't do a Rule 6. You understand? But y'all should have read Rule 1, Rule 2, all the way up to Rule 20 or whatever rules, how high it goes, right? Specifically, y'all should have read Rule 8, Rule 9, Rule 10, Rule 11, Rule 12, all the way up to 17 at least. Y'all never did it. And this is what I mean by when I be like, yo, y'all ain't studying correctly. Y'all don't know what I know because y'all ain't taking y'all studying seriously. You must know the rules of court, right? Court is waging war. It's waging war against the powers that be for the rights that was given to you by God. You got to know the rules because anytime you don't do the court rules, they do, like I said, Rule 12b6 on you that you have stated a claim where relief cannot be granted. So if you don't want that to happen, you want to win your case, you got to know the federal rules of procedures. Now, the good thing is the federal rules of procedure works for any case on the state or federal level, but you're just not going to say uh, federal rules of procedures, procedure 10. No, you're not going to put that on the paper. You're just going to do what the rule tells you to do if you're in a state case, but you're not going to name the rule because the state has it under a different code. Okay? Now, so with that being said, let me go over Rule 10 because a lot of y'all are working on these 241, 242 suits, right? So even though I got the template and the template is correct, I want y'all to know why it's set up the way it's set up. So if you go to Rule 10, and let me put this in the chat. As far as I know, I'm the only one that actually shows y'all the rules to court because I always said all these years, all roads lead to court. So I'm like, I'm gonna be different from all the other Moors. I'm gonna be obedient and follow what Noble Drew Ali laid down and follow the rules that the ancestors laid down. And I'm gonna beat them at their own game. A lot of people don't want to do that. A lot of people think it's too much trouble to do that. Well, then it's too much trouble for you to win. Plain and simple. You know what I mean? So I put it in the chat, Rule 10. Hold on, let me put it in YouTube as well. I got to get used to putting stuff that I put into the chat into YouTube so people can check it out on YouTube as well. Instagram, y'all asked out. I have no way of putting that up there for you. Y'all gonna have to just listen and follow. So it says, form of pleadings. Rule 10, form of pleadings. A, caption, names of parties. Every pleading must have a caption with the court's name. a title, a file number, and a Rule 7A designation. The title of the complaint must name all the parties, the title of the pleadings, after naming the first party. Each side may refer generally to the other parties. So once you name the parties in the header, you know, Jonah Bay versus Georgia, the state of Georgia, by taking in Georgia governor, whatever his name is, doing business as the governor, right? That's the parties. Now, every time in my paperwork, I can refer to them as the other party. I don't have to keep on putting their name specifically anymore. I could say the other party, right? So y'all got to know y'all are able to do that. All right. So rule B. Now the funny thing is, someone was working on a case, and I said, now I showed them rule 8 and lined it out what it was they were supposed to do. Matter of fact, hold on, let me pull up rule 8 and show y'all what I'm talking about. I'm really flabbergasted at the way people really can't comprehend what they read, can't comprehend what they're doing. It's y'all got some studying to do for the comprehension, because if you're not comprehending, you're really not reading. Rule 8, general rules of pleading. A claim for relief. A pleading that states a claim for relief must contain: number one, a short and plain statement of the grounds of the court's jurisdiction. Guess what? Yo, all the paperwork I've seen thus far for 241s, when people get in consultations to do the 241, they fucked that up already. They don't have jurisdiction in number one. It says number one, jurisdiction. You have to name how the court has jurisdiction. That's number one, because they got to know how they're able to hear the case. That's number one. They had a short, plain statement. Had it wrong. I said, switch that shit around. Fuck the matter with you? Oh, my bad. I didn't see that. How you didn't see that? I read the last consultation, Rule 8 to you, made you read it, asked you questions, and you still got it wrong. Y'all got to do better. Number two, a short and plain statement of the claim showing that the pleader is entitled for relief. That's when you do a summary of what the fuck they did to you. They violated my rights protected by the Constitution by doing a false arrest and stopping me illegally. That's a short, plain statement, right? Then you go claim number one, and then you start going into the details. It's done just like a book is done. When you open a book, you got the glossary or the index, and it tells you a short, plain sentence of what the goddamn book is going to be about in every chapter. Y'all seen it your whole life. I don't understand how it's so difficult to do. You know, I think the governments of this world did a real good job with dumbing us down. It's like really crazy what the average people don't comprehend and don't see and don't understand. Then, number three, a demand for relief sought, which may include relief in an alternative or different types of relief. Now, even the shows on the radio, you heard this. I'm going to go to it in a second. But every goddamn piece of paperwork I seen came in, it says prayer for relief. Prayer. Well, Jonah, your template got prayer. I said, I know what my template got. It got traps in it for the people who want to steal my paperwork. But for y'all that listen on the air, I tell y'all what to fucking do. I tell you what it says. The word says demand. Demand. Demand is not a prayer. Look up the fucking word prayer, and you basically saying these people is your God. How you gonna make a man your God? What the fuck you doing praying? The goddamn lawyers write the word prayer for relief. Even this rule tells you to demand. I demand this relief. That's what it's supposed to say. I demand this relief. The fuck y'all doing? Do y'all not comprehend what it said? A demand for relief sought. Now, a lot of people were asking me, well, Jonah, you don't have the pay fee schedule or how much they want. I said, yo, I've been telling y'all a long time ago, $9,000 per minute, and refer back to your daggone injunction that you said $9,000 per minute and charge them. That's called or alternative or different types of relief. An injunction is called an alternative or a different type of relief. Y'all gonna have to comprehend what y'all are reading. Don't just read it to read it. But these are the problems people are having with Rule 8, not comprehending. I'm not going to go further into Rule 8 because I've done it so many times inside the archives. I'm concentrating on Rule 10 tonight, right? So then it says B at Rule 10, forms and pleadings. Paragraphs separate statements. So it just told you to do paragraphs with the separate statements. A party must state its claims or defenses in numbered paragraphs. You know how many people's paperwork I seen that didn't have the numbers on the side? You put the numbers on the side so when someone's rebutting it, they can refer to number 16, the first paragraph at number 16 of the page. That's why you do that. You're supposed to do that. Y'all ain't doing that. If you don't do that, you can get a Rule 12b6. They stated a claim where relief cannot be granted. A lot of y'all be having run-on sentences. Ramel, all y'all niggas that did that bullshit case had run-on sentences. Didn't have no numbers. Yes, niggas, I'm talking to y'all. Y'all did it wrong. I'm not saying it. The law's saying it. I don't know why the fuck y'all get mad at Jonah. I'm just reading the laws to y'all, making sure y'all comprehend it. But let me go on. A party must state in its claims and defenses in numbered paragraphs, each limited as far as practical to a single set of circumstances. That means talk about one subject at a time. After you talk about that subject, then you do another paragraph with another number on it and then talk about that, right? Simple. A later pleading may refer by number to the paragraph in the early pleading. Now, I like to say the above mentioned Constitution. And then I'll start talking about it. Because I had the Constitution right above what I was about to start talking about. You see what I'm saying? So a lot of y'all are just fucking up. Y'all want to do what y'all want to do. Y'all are disobedient. Yo, my niggas, y'all can't be disobedient. You're gonna have to follow suit. You know what I mean? A lot of the Moors are fucking up and always losing court. Why? They disobedient. Noble Drew Ali said, take on a new name and do business in your new name. Then he also said the young Moors would come and take it further than him, and the old Moors would have to take a backseat. Y'all should have been looking for young Moors to teach you, not Taj Tariq Bey. He wasn't going to fix it. He an old Moor, right? Then Noble Drew Ali said, enforce the Constitution. As far as I know, I'm the only one that teaches y'all how to enforce the Constitution because I'm obedient to what Noble Drew Ali said to do. And that's why I'm the most successful. Money-wise, winning cases, getting y'all remedy when y'all doing y'all's own case. You know what I mean? That's why it's going down. I know how to follow directions. Let me go on and finish reading. A later pleading may refer by number of the paragraph in the earlier pleading. If doing so would promote clarity, each claim founded on a separate transaction or occurrence, and each defense other than a denial must be stated in a separate count or defense. So you have things called count one, count two, count three. So when you're doing a different paragraph on a different subject, you always put count one. Then the next count, you say count two because it's a different paragraph with a different subject. This is the way it has to be done. Y'all niggas is just throwing up motherfucking lawsuits with run-on sentences and everything. It's crazy, right? All right, C, adoption by reference in exhibits. A statement in a pleading may be adopted by reference elsewhere in the same pleading or in any other pleading or motion. A copy of the written instrument that is exhibit to be a pleading is part of the pleading for all purposes. So when I'm talking about the Constitution, I cut and paste it inside the paperwork and say the above mentioned Constitution. Or if I have the whole Constitution, I have it as exhibit A is connected to my complaint. And then I mentioned the specific part of that Constitution I'm talking about. Clause one, motherfucking section 2, paragraph 4. See what I'm saying? And I keep on doing that throughout the whole document when I'm doing exhibit. I tend not to want to do exhibits, so I cut and paste the whole Constitution. I mean, the part, at least the part I'm talking about, into my paperwork. Just makes it easier than doing the exhibit, right? So that's Rule 10. How many of y'all knew Rule 10? I thought I would be doing Rule 11. I'm going to try to do Rule 11, see if I got enough time to do Rule 11. All right. So Rule 11, let me put this in the chat in YouTube. Y'all going to have to get back to this scientist stuff. Y'all got to start operating like scientists and do all this shit correctly, yo. Follow the rules. Be obedient. Y'all, a lot of y'all niggas want y'all women to be obedient, but y'all ain't obedient to no one. You don't listen. She ain't gonna listen. Fuck you doing? And then if the parents ain't obedient, how you gonna expect the kids to be obedient? You do all of this stuff by example. You got to live your life by example because people are looking to see if you're a hypocrite. And no one respects hypocrites. How was the movie? Big girly movie. Girly. Girly. I told you Whitney got Bobby Brown hooked on drugs. I know, but she introduced. Yeah, I'm on the show. Oh, my bad. My bad, y'all. My bad. We talking about that Whitney Houston movie. They went to see it. I didn't go. I ain't watching girly movies. So I just put it in the chat. Let's go to Rule 11. Rule 11, signing pleadings, motions, and other papers, representations to the court sanctions. We ain't gonna really read the sanction part because I don't care about that. Signature. Every pleading, written motion, and other paper must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is unrepresented. Now, you know how many times y'all get attorneys, they never sign the paperwork? That means you didn't even have an attorney represent you. That's one of the tricks that they're using to fuck you over, right? But you're supposed to sign your own paperwork. Not only do I sign all my paperwork, with my address and all that stuff, I also put the day I get it authenticated. I mean notarized. Why? Because I make everything an affidavit. I make everything an affidavit. Then it says, or by party personally if the party is unrepresented. That's y'all. We going in unrepresented. The paper must state the signer's address, email address, and telephone number. How many of y'all are putting y'all's address, email address, and telephone number on the page? I do. I don't tend to give them my email address. I only give them my address, telephone number. I don't want them to have my email address. Unless a rule or a statute specifically states otherwise, a pleading need not be verified or accompanied by affidavit. See, need not be. I do everything with an affidavit. The court must strike the unsigned paperwork unless the omission is properly corrected after being called to the attorney or party's attention. They never tell you that they're striking your paperwork, all because you don't have your name, your address, email, and telephone number on the paper. They just strike it. And you be like, yo, Jonah, they ignored my paperwork. And I say, let me see your paperwork. And you show me the paperwork, and I'm like, yo, you didn't do this. You didn't do this. So now your paperwork got striked just because you didn't put your phone number, your name, your address, your email. Did y'all know that they was striking your paperwork for that? I did. And see, this is why a lot of y'all do the paperwork on your own. Y'all don't get the consultations for me to look at your paperwork. And y'all be like, yo, it didn't work. That Jonah Bay shit don't work. Yes, it does. But you should have got the consultation because you didn't do the proper studying. You don't know the rules. So they strike your paperwork. So I said, yo, it's time for me to actually tell y'all the rules that I follow and the rules that I know, but y'all should have did it on your own. Y'all always waiting for Jonah Bay to show y'all. That's where your real mistake is. Don't wait for me to show you. Take the initiative and do it on your own. Right? So yeah, y'all's paperwork is getting stricken from the record. B, representation to the court. By presenting the court a pleading, a written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that it is to the best of the person's knowledge, information, and belief formed after the inquiry reasonable under the circumstances. Right? And it says, number one. Now, personally, I have y'all always do what? It's called unsworn declaration. Google unsworn declaration. And you do it, all affidavits, without the United States. You do it under the laws and the treaties of United States of America. Number one, it is not being presented for any proper purpose such as harass, cause unnecessary delay, or needless increase of cost of litigation. Number two, the claims, defenses, and other concoctions are warranted by existing law and by non-frivolous arguments for extending, modifying, and reversing existing law or for establishing new law. See, when I went into, last time I was in federal court, did a case, they wrote these things and said my case had merit. And they went on with the case. They tried to get it dismissed and they couldn't because I followed the rules. So then he wrote this according to the rules. See, when I'm in court, I'm not surprised. I know what they're supposed to do and I expect it to be done. And if they don't do it, I do a writ of error. Dum, dum, dum. Let me go on. Number three, the factual contentions have evidentiary support or specifically so identified or likely have evidentiary support after a reasonable opportunity for further investigation or discovery. See? So when they trying to shoot your shit down, this is the shit you write. If you given more time to show your shit in discovery, it's going to show what you're saying is absolutely true. Like when you make the statement that the officer stopped you and didn't have a warrant, nor did he have an affidavit in support of the warrant, which is a violation of my rights protected by the Georgia Constitution and the federal Constitution. And discovery will show this by me asking for discovery of those things, and they won't be able to produce it. So therefore, the case gets shut down immediately. Right? And number 4, the denials of factual contentions are warranted on the evidence, or if specifically so identified, reasonable based on belief and lack of information. They just told you, you get shit shut down just by saying I deny. I've been telling y'all that for years. Why? It's in the rules. So that's rule 10 and 11. We're going to next show talk about 12 and 13. But with that being said, we passed the time. I'm going to start opening up the call lines, but before I do, I want to play something. Because I used to play this shit all the time. And I don't know, I got out of playing it. But I need to play it way more. Because it's definitely something y'all need to learn. This is why you poor. Right here. I'll be back.
Matthew and I were discussing some of the things about why you discounted on a subconscious level some of the things that have happened, because absence of evidence is not evidence of absence. And he said something very profound. For an Australian, this is heavy duty shit. But he said, I decided to do it, even though it was stupid, I decided to do it. Stupid meaning follow the process, to an intellectually bright guy who's an engineer. And see, you won't. You see, you'll figure out a better way. And he followed the stupid process that works. And it's been working for 45 years, 20 some years before when I was doing it, and 22 years since I've been coaching. And he called it. He wasn't trying to be insulting or anything. He said, I just decided to follow this, How did you say it?
Instead of trying to be smart, I would just try to be stupid, shut that part off of my brain, and just do it.
And what happened? He did it. And that's why it's hard for the YouTubers and all the other, because you can't dumb down. You will not believe that it's easy. You can't, you won't. But he put it very succinctly. He just dumbed down and shut off that part of his brain and just follow the steps. You don't need fucking case studies. You have a fucking template. You have a motherfucking script that a fucking monkey can read. That Alex wants a fucking case study because he wants to know the shit behind it because he's stupid. And that's why he's fucking poor. You don't need any motherfucking case studies. How many fucking times do I have to say? You have the fucking script. I said, don't change a fucking word on the script. Not a comma. If it's got misspelled fucking words, send it out misspelled. The last thing you fucking need is a fucking case study. This is why you're fucking poor. This is why the cocksuckers watching this on YouTube are so fucking poor.
All right. Follow the fucking script. That means follow the motherfucking rules, y'all. All right, let me open up the call line, see what's going on out there. Stay on point, talk about the subject before you start asking me questions on other things. I'm going to 636-249. Peace to the God. Peace.
Peace to the God.
What up,
Peace,
God?
God. What's going on?
I'm
Great
chilling.
show, great show. You
Thank
know what? Look, I've been out here for a while with you, and it never ceases to amaze me, like how much, even when you're doing your own study and stuff like that, to be able to listen to you speak, and it's just that much easier to comprehend. Even though you think that you have a overstanding of something, when you say something, it's just like it's just like an insurance. Like,
Well, thank you. Thank you.
Reinforcing, like, yo.
I never thought of it that
I'm
way.
gonna tell you.
I never thought of it that way.
Yeah, that's exactly.
But I was looking flabbergasted. I talked to 10 people, and Rule 8, number one, they did not put jurisdiction. And I asked them, I said, yo, listen, you read this. I know you read this because we read it together. I said, why didn't you put jurisdiction as number one? I said, yo, were you using a template that you found online or you got it from somewhere else? And they admitted it. They used someone else's template. I said, see what I'm saying? That's the fucking problem.
I always get it. You know what? It's always that.
It's always that. It's all the only reason to use someone's template is because you don't know how to do it yourself. But if you read the rules, you know how to do it yourself. Yo, a lawsuit is very simple when you're following Rule 8. Yeah. If you do Rule 8 correctly, all you gotta do is Rule 8, Rule 10, and then you could never get a Rule 12b6.
That's what's up. You see, just that right there alone, you just made it clear. You made it simple, because I would run into that sometimes. I'm like, I got this. Establish jurisdiction. I put my I number my document. I would do post A. I mean, I never mess around with attorney.
Right.
And but they still have to throw out that 12D book. Here and there, not all the time.
Right.
And then they try to run away from providing, discovery and stuff like that. Even when I will not force the judge. Anyway, when you ask the judge to make these people force their hands on the discovery.
Compel discovery.
Yeah, compel the discovery. I always say you said 12D or try to run away from discovery. But you just made it a lot clearer. I mean, even though, I went over it plenty of times and I wrote it out, that you coming from your mouth is just reassuring. But I'm not going to hold the floor. What I wanted to also ask, I forgot. So I'm going to fall back and listen. I appreciate it. Peace to God.
Peace to the God. All right, I'm going 561-856. Peace to the God. Peace.
What's going on? Peace, Jonah.
What up, God? How are you?
I'm all right, man. I just want to say that commercial, man. It had me laughing when he get to that Escalade. You know what I'm saying? When he said fucking monkey, it's just funny.
It is, ain't it? I think it's hilarious.
Yeah, man. So I'm on. The rules. This whole rules section I had last week, I had no clue what the hell was going on at all. And like you say, just kick archives. I push about 2 hours with Jonah Bay a day, and it's crazy. I still don't know how to do none of this stuff.
But I bet you catching up.
You know what I'm saying? Yeah, man. Yeah, I really appreciate it. You know what I'm saying? So much flowers. Right now, I appreciate it, man.
Well, I thank you, brother. I appreciate that.
So yeah, man, I'm just I'm pushing forward. Like I said, I got a few questions.
All right, what you got?
Get to that. Well, my first one, I got the injunction and everything printed out or whatnot from your website. I just wanted to know who do I send it to exactly? I did the Florida injunction.
Okay. These are the people you send the injunction to, the driving injunction. You send it to the governor. The governor is the president of the actual state. He's the president, right? You send it to the attorney general. The attorney general is the attorney for the whole state. You send it to 3 sheriffs in 3 different counties where you drive. You do that, you're straight. You don't have to send it to no one else. I've heard people sending it to DMV and all that. You don't have to send that there. DMV are subcontractors. DMV is not the state. Actually, police officers are not the state. They are contractors too. So the only law in the state is the sheriff's. Now the sheriff deputizes all of the police, just like you seen a cowboy movie and they be like, we're gonna form a posse. And for catching this person, we're gonna deputize all of y'all, and y'all gonna be deputies under this sheriff, and we're gonna go hunt this guy down and find him. That's what the police are, deputized by the sheriff.
Okay, got you. Okay. And my second question would be, I got the child support injunction, and I just wanted to know. I'm trying to still figure it out and look up the Constitution.
Great. But, great. Hold on.
Is that?
Hold on.
Okay.
Hold on. You're gonna send me your order number for the child support injunction that you ordered. Go to send it to jonahbay@gmail.com. Why? I made an easier and better child support injunction, and I'm gonna give you the copy because you already bought it.
Okay, appreciate that.
No,
appreciate that. And my last question is, should I get a consultation about how to get a DBA in Florida? That's my
nah, you might as well not do that. You're gonna have to read that. I've never looked up the laws to get a DBA in Florida and never cared to because I don't live there.
Gotcha. Okay.
Now I'll tell you, once you do your child support paperwork, you need to get a consultation so I can look over and make sure it's correct.
Got you. 10-4.
Okay.
I got it. That's on that.
Mm-hmm.
Got you on that. Well, all right, man. That's all the questions I know. People. I've been trying to get to you since last week.
Well, welcome, brother.
I'm
welcome.
Year the floor.
All right, peace,
like
God.
I said, man, you're beautiful. Thank you.
No doubt. All right, I'm going to the next caller. I'm going to 336-866. Hurry up. Say what you got to say. Don't do all the greetings. We only have 5 minutes left. Peace to the God.
Well, peace. You're doing a great job, bro. Keep it up.
Thank you, bro. I appreciate it.
Yeah. Following that Constitution, man. That's one thing you always said, man. You always said move swiftly, and with this shit, you gotta move on them. Because if you don't, slipping with the fucking, I missed that fucking appeal, and that shit, they just move forward, man. I had him beat, but I ain't get the appeal in time. But that procedure shit is real.
Yes,
because,
sir.
The lower courts don't follow none of that shit, bro. I mean, they only follow procedure. They don't follow nothing else.
Right. And that's why I'm saying we got to do the procedures correctly.
Yeah, they don't care about none of that shit. If you're not following civil rules, federal rules, procedure, you forget about it. They're gonna
forget about it.
Straight up.
It's for real, though.
For real. That's fact. Yeah. That's why, So the guy he told me, he said, yo, use that discovery. You put that discovery on them, and that was it, bro. They don't answer that shit. They keep it moving. They keep it moving. They don't answer, and they keep it moving. And Jonah, one other thing too. Now, I don't know if I think you having this issue too, but you already, you got something for it. And what I'm noticing now, I had the injunction on the witch for a minute. And now what they doing now, because, it's in my spiritual name. So now, this the regular police, the sheriffs and the state troopers ain't doing that shit. It's the city cops.
Mm-hmm.
So now they taking, instead of the Energy L Bay trust, they just take the Energy L Bay and they say, oh, he ain't got no license. Straight up. That's what they doing now.
Dog, have you,
like,
hold on. Let me ask you a few questions.
Mm-hmm.
You got your IDP?
Yes, sir.
You got your IDP?
Oh, no, I ain't moving. No, I know that's the solution.
Yeah, you're supposed to have an IDP, and you're supposed to have your private foreign license, and you hand that to them because the peons are used to seeing something, right? They're used to seeing something. Now, the thing is, our biggest problem out there is the cops that don't know anything. They're going to violate you not knowing, right? Now, I made something for them motherfuckers too. It's called the 241, 242 suit. That was false arrest and false imprisonment. Go get your money.
Sure indeed.
Yeah, go get your money.
On the way. Already.
And what's going to happen after you even attempt to sue them? This is what they do. They put your name in the database and say, leave him alone. Don't ever fuck with him. Because you're going to get sued. They spread your name to everyone in the vicinity. Just for the lawsuit. Whether you win or lose, they're going to do that. Why? Because they already know even if you lost, you're going to keep on doing it. And eventually you're going to win.
Right. Okay, so I know you dropped this shit in March because that's gangster right there. That's what I'm looking to want to do that. Like, in other words, have a case already going on and then turn around and sue them within the case.
Exactly.
Like,
the rules that I'm going to read to you next week or so is going to show you how to take their case and make it to your case and put it in federal court. The rules tell you how.
Right, true indeed.
Mm-hmm.
True indeed.
All right, peace, God. It was wonderful talking to you. Peace to God.
Yeah, peace, bro.
All right, that's our show for today. I gotta get off on time because I'm doing an interview that will be going up soon. That a brother is interviewing me. So I gotta get up out of here. Peace to God. I hope y'all enjoyed the show. I hope y'all learned a lot. I hope y'all go back and study those 2 rules we went over today and learn them and put it in your repertoire. You know what I mean? All right, we out of here. Peace to the God.
Thank you for using Blog Talk Radio. Goodbye.
All right, YouTube, we out of here. Hope y'all enjoyed the show. Peace.